Hello, everyone. Welcome to this CLE event called Understanding Paga after the U.S. Supreme Court's decision in Viking River Cruises. This event is being thrown by the Beverly Hills Bar Association Labor and Employment section. My name is Nazgole Hashemi. I am the vice chair of the Labor and Employment section. Starting in October, I will be the chair of the section. I am the co-founder and an attorney at LegalAxxis Incorporated. I practice general civil litigation with a current emphasis on employment and business litigation. For employment, I typically practice on the plaintiff side, and I do defense when the employer does not carry insurance. I'm going to turn the floor over to our two wonderful speakers so that they can introduce themselves. We have Hannah Sweiss and Max Gavron. Starting with Hannah, go ahead.
Thank you, Naz. So as Naz mentioned, my name is Hannah Sweiss, and I'm thrilled to be here this evening with two of my law school colleagues, Naz and Max. And Max and I have actually had the fun of being opposing counsel. I'm a partner at Fisher Phillips, a national labor and employment law firm. I've been practicing defense side employment law since the outset of my legal career. I handle a wide variety of employment law matters, and I do focus some of my practice on wage and hour issues, class, collective, and Paga actions, as we'll talk about tonight. I'm also, used to spending a lot of time, particularly during the pandemic, providing advice and counsel work.
Thank you, Hannah. Welcome.
Hi, everyone. My name's Max Gavron. I am a lawyer at a firm called Diversity Law Group. As Hannah said, the three of us went to law school together, so it's nice to be here today to be able to talk about Paga. I practice plaintiffs' employment. I would say 70% of my caseload is class and Paga cases, and maybe 30% is individual actions. I've been doing that for about the last 4 years. Before that, I practiced at various defense firms.
Great. Thank you, Max. Welcome. So Max is going to be our plaintiff's perspective tonight, and Hannah is going to be our defense perspective. So you guys should have received written materials, and inside of those materials, you're going to find various cases. So of course, you're going to find the Viking River Supreme Court decision. I have also included the petition and the responsive brief. You will find the California appellate decision and the Superior Court decision. We've also included the Ascanion case and the Lamps Plus case, which we will discuss shortly. And that's about it. We have a whole lot to discuss tonight, so let's just go ahead and jump right in. Okay, so we're here tonight because of the Viking River Cruises Incorporated versus Moriana Supreme Court decision. This decision abrogated the California Supreme Court decision Ascanion versus CLS Transportation Los Angeles LLC. I'm going to start with having Max discuss the Ascanion decision so that you guys can have a foundation as to the Viking River decision, which Hannah will then discuss. Both of them are going to discuss issues of preemption under the Federal Arbitration Act, FAA. And just to give everybody a little bit of an agenda as to what we're going to be going through here today, later on, we will discuss the meaning of representative in terms of Paga, arguments for and against compelling arbitration, the Superior Court's jurisdiction pending arbitration, settlement of Paga actions, and judicial or legislative responses following Viking River. So I will turn the floor to Max, and he will explain the Ascanion case for us. Go ahead, Max.
Thank you. So before we get too deep into Ascanion, I just wanted to provide a little bit of background on the Paga generally. And I know most folks are probably familiar with this, but just some of the high points I think are important to set the stage. So the Paga was enacted by the California legislature in response to the need to be able to better enforce the labor code for California. And so the main purpose of the Paga is that, to enforce the labor code. And because that's the case, in a Paga action, the lion's shares of any penalties that are collected goes to the state. 75% of any sort of recovery goes to the state, and 25% is distributed amongst the aggrieved employees. There's also some administrative requirements prior to filing a Paga action. And one of the most important things for purposes of Iskanian and Viking River is that the real party in interest in a Paga action is the state of California, as opposed to the individual who is bringing the case on behalf of the state. So with that kind of background, we can talk about Iskanian. So under Iskanian and up until Viking River, where an employee had signed an arbitration agreement that included a waiver of a class claim or a Paga representative claim, Iskanian controlled and essentially held that representative Paga claim could not be waived by virtue of an arbitration agreement, even if a class action could. So from a practical standpoint, if you had an employee who signed an arbitration agreement that had one of those waivers, you may lose the class action component of the case, but for all intents and purposes, the Paga action would continue in court. So Iskanian, in getting to that holding, they evaluated first whether it was permissible under state law to waive the right to bring a Paga action. And the court concluded that it was impermissible because there is a strong public policy in California to enforce the labor code. So given that that is the kind of state law that is protected, the court went on next to evaluate whether the Federal Arbitration Act preempted that state law, right? Because you can have a state law that is preempted by the Arbitration Act. So the California Supreme Court analyzed it and ultimately concluded that that waiver rule in Iskanian was not preempted by the FAA. And the thrust of the reasoning there was that the purpose of the FAA was to promote arbitration between private individuals for private disputes. But in a Paga case, the dispute is not a private dispute. It's in fact a dispute between the state and the employer. And therefore, it simply falls outside of the preemptive reach of the FAA. There's a lot of intricacies you can get into if you really want to dig into Iskanian, but I think those are kind of the key points. What I'll end with is something that I found very interesting. At the end of Iskanian, the California Supreme Court posed a few questions, which we're revisiting now after Viking, and they were whether the parties would agree to a single forum to resolve their Paga claim and their quote unquote individual claims. And if there was a bifurcation of those claims, what would happen to the Paga claims pending resolution of the individual claims?
Thank you, Max. That was a great explanation. Hannah, go ahead and explain Viking River for us, please.
Okay, great. Thanks. So yeah, so I mean, I think Max, right, like in setting up that, you know, the backdrop there with Iskanian and how we end up here with Viking River. And this was right from the defense side, the opportunity to take this up and see, you know, can we change that? Because we've all been fighting with that, right? Having all these Paga cases just in court and not having them, you know, arbitrated. So now we have Viking River. What was Viking River Cruises about? So what was this actual case about? And I'm sure many of you have heard of Viking River Cruises, that famous company that offers ocean and river cruises. And Viking River Cruises was the employer in this case. And Moriana was the employee. She was a sales rep who signed an arbitration agreement on hire. And she agreed to arbitrate any dispute arising out of her employment. And the agreement contained a clause that said class action waiver, and it had the language, and it provided that in any arbitration proceeding, the parties could not bring any dispute as a class, collective, or representative Paga action. It also contained a severability clause, which has become very important, that if the waiver was found invalid, any class, collective, representative, or Paga action would presumptively be litigated in court. But under the severability clause, if any portion of the waiver remained valid, it would be enforced in arbitration. So despite signing this arbitration agreement, after she left her position, Moriana filed a Paga action against Viking in California court. She alleged that she wasn't timely paid her final wages, a claim we often see. And she also asserted a wide array of other labor code violations, minimum wage, overtime, meal periods, rest periods, timing of pay, pay statements, and these are really the usual claims we see in Paga cases and class wage and hour cases. Viking then moved to compel Moriana's individual Paga claim. And we'll talk more about that because that's something, somewhat new here that we're seeing out of the Viking River decision. And sought to dismiss her representative Paga claim, arguing that the US Supreme Court's decision in Epic Systems overruled Iskanian. And that on that basis, the court must enforce the arbitration agreement according to its terms, because basically the state law rules prohibiting class action, collective action, or representative action, as we're dealing with Paga, all convert an individualized arbitration agreement into something that is not arbitration as envisioned by the FAA and cannot be required by state law. So the plaintiff, Moriana, opposed the motion, relying heavily on Iskanian, as Max just described. And the trial court here in California denied Viking's motion, going with plaintiff's arguments. On appeal, that decision was also affirmed, again, going with Moriana's, version, and holding that the categorical waivers of Paga standing are contrary to the state policy, and that Paga claims cannot be split into individual claims subject to arbitration. Viking then took the case up to the US Supreme Court, and the US Supreme Court, which is now the decision that we have, granted cert and reversed this holding, and it ended up holding that Iskanian's rule that Paga actions cannot be divided into individual and non-individual claims is preempted by the FAA. But Viking did not go as far as saying that these wholesale waivers are preempted by the FAA. So that's a point that really needs to be emphasized. The thing that was preempted was that this claim splitting issue is that they could be split into two separate claims.
Thank you, Hannah. So Hannah and Max, they just laid the foundation that we'll need for tonight. Iskanian is the case that was in part overruled by Viking River. So after Viking River, various issues have come up in practice and just practically speaking that we're going to get into now. So the first issue we want to discuss is the representative language that appears in arbitration agreements. The Viking River decision discusses two different meanings of the term representative, as this term relates to Paga in particular. So Hannah, why don't you describe for us, what are these two meanings of representative? Why is it relevant to the Viking River decision? And what is your perspective from the defense standpoint on whether a plaintiff can pursue a representative claim in arbitration?
Okay, thanks, Naz. Yeah, and so, the decision does really have an interesting discussion about the two different meanings of representative. And, the way that it's described is that there's these two representative ways that plaintiff pursues Paga. In the first sense, Paga actions are representative in that they are brought by employees acting as a representative or an agent of the state, kind of as Max described earlier. And then in the second sense, Paga claims are also representative when they are predicated on code violations sustained by other employees, that's bringing them on behalf of other aggrieved employees. And that's kind of the discussion that was actually in the Viking River decision. So when we discuss this individual and non-individual Paga claim, they're representative, both of them, because all of the Paga actions, again, now with this new idea of having an individual Paga action, is still representative. The court in Viking did note that when using this word representative in this second way, where you're representing on behalf of others, we should break it down further to talk about it in an individual sense or in a non-individual sense. And I think today when we're talking about it, we're going to talk about it that way. But I think it's, important that we're talking about this in that both ways are still representative. But now kind of back to the question that you originally asked, Naz, in answering it, what are my thoughts on whether a representative claim can be compelled to arbitration? So in the first sense, under Viking, because even the individual claim is representative, then yes, I think that one can be, right? The individual Paga claim can be compelled into arbitration. But in the second sense, can someone actually bring a Paga claim and pursue it on behalf of others in arbitration? My answer there is no. And I think the Viking decision does support that. And I think even in, Justices Barrett and Kavanaugh's concurrence in part 3, they further focus on the discussion, which is that the court can't force, if there is a binding arbitration agreement, to compel aggregation of claims into arbitration.
Okay, so from the defense perspective, the individual Paga claim can be pushed to arbitration, but the non-individual ones cannot.
Correct.
Okay, so then Max, why don't you discuss for us there is a discussion in Viking River regarding joinder of claims. And so I think the Lamps Plus decision is relevant here. Why don't you describe the Lamps Plus decision for us and then give us the plaintiff perspective on whether a plaintiff can pursue a representative action in arbitration, or is there some kind of joinder issue?
Sure. So the Lamps Plus decision is a decision out of the United States Supreme Court that held essentially that unless an arbitration agreement specifically provides a mechanism for a class-wide or representative arbitration procedure, you can't force the employee, can't force the employer to participate in a class or representative arbitration. And what's underpinning that is really contract principles of the fact that the employer didn't agree to that. And in reasoning, getting to that point in Lamps Plus, the court had previously held in a case called Stolt-Nielsen that where an arbitration agreement is silent as to whether class arbitration is appropriate, you can't have it. And of course, these Supreme Court cases, we have to keep in mind, were applied in the class action context, but they really are the best view we have into how things will be handled moving forward in the Paga world. And it can admittedly get confusing. So one thing I just wanted to raise about this issue of claim joinder and whether the quote unquote individual Paga action can be arbitrated. The Moriana, the plaintiff from Viking River, recently filed a petition for rehearing at the Supreme Court. And we were all talking about that a little bit before today's presentation. And one of the arguments that was made there that I thought was interesting, and I tend to agree with, is if Viking River held that the Iskanian rule precluding the waiver of a representative claim is not preempted by the FAA, then you shouldn't be able to compel an individual Paga claim to arbitration because it is inherently representative. That is, you're standing in the shoes of the state bringing the case. We'll see what happens there. It's a complicated thing, and I don't know how that'll play out.
But I was going to say, Max, kind of to that point though, and you're saying like looking at, the basis in which I think they're saying, the representative part, and again, it's not exactly the same as class or collective. I think the reasoning there is on this point, right, is really looking at that LAMPS plus and, being able to not allow class or collective claims in arbitration, similarly not allowing these aggregated claims, even if they are representative.
Right. I think that's really what it boils down to, is where we started on this, the claim joinder issue of, can you have multiple claims from different employees in arbitration if the arbitration agreement doesn't provide for it? And I think right now, unfortunately for the plaintiffs, the answer is probably no.
But just to be clear, from the plaintiff perspective, then you're saying that because a Paga action is inherently always representative, then the individual claim can't be forced into arbitration either, because in essence, you're forcing the state into arbitration. Is that correct? That's
the argument. Yeah, we'll see. We haven't had an opportunity to really flesh all this stuff out. I'm sure, I have a lot of cases, and I'm sure you guys do, where we'll find out what the courts will do with all this.
Okay, so I think that's a good segue into our next topic, which is compelling arbitration. So if we have a situation, and I'm going to start with Max on this one, for the plaintiff's perspective, if the defense wants to compel arbitration or requests a stipulation to arbitrate, then what are some arguments on the plaintiff's side for not going to arbitration?
So the way I think about it is kind of, in my mind, as like a decision tree of what do I need to look at to know how to oppose this request? And the first place to look is the language of the arbitration agreement. If there is no Paga waiver in the arbitration agreement, then the Paga action can proceed in court. If there is a Paga waiver, and then you need to look to see whether there's a severability clause in the arbitration agreement. Because if there is not a severability clause, then you can argue that the arbitration agreement violates the Iskanian rule that still remains, right? That you can't waive a representative Paga claim. And you can argue that the arbitration agreement is invalid. If you come across an arbitration agreement that kind of checks all of those Viking River boxes, then you have to get a little bit more creative to try and figure out, what the angle is that you can try and oppose this. So one of the things that has come up in the last few years, the California legislature passed a bill that codified Labor Code section 432.6. And so this code section essentially precludes employers from forcing employees to sign an arbitration agreement as a condition of their employment. Now, from experience, we all know that most employers do exactly that, or at least they had been doing exactly that. Not surprisingly, this Labor Code section was challenged, and it was challenged by the Chamber of Commerce. And they sought a preliminary injunction, finding that it was preempted by the FAA because it interfered with the employer's ability to arbitrate. So that case is a case called Chamber of Commerce versus Bonta, and it went up to the Ninth Circuit. I should add that this labor code section, in addition to precluding employers from requiring arbitration as a condition of employment, also provided some penalties for employers who did that. And I don't recall exactly how much it was. So anyway, at the Ninth Circuit, the court analyzed the statute and performed the preemption analysis, which is a little bit tortured, but ultimately found that the statute was not preempted by the FAA, at least a portion of it, because it regulates pre-arbitration conduct. In other words, the statute is regulating what employers do before there's any sort of arbitration agreement in existence. So it can't be within the preemptive reach of the FAA. It's a creative argument, and that's kind of where things stand on that now. The Ninth Circuit did hold, though, that the penalty provision of that statute was preempted. So in Chamber of Commerce, the Chamber of Commerce filed a petition for en banc review that's still pending. After Viking River, they filed a letter essentially asking the court to consider Viking River in deciding whether to grant en banc review on that issue. Another thing that has crossed my mind is there are, ultimately, I think a legislative response will happen, and we'll talk about that a little bit more. But another example I thought of is earlier this year, federal Congress signed into law the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act of 2021. And in that legislation, it precludes arbitration agreements that waive, well, I should say, it precludes the arbitration of claims or cases, rather, that involve sexual assault or sexual harassment. And it does also apply to class or collective actions. And so if you have a scenario where that is an issue and there's an arbitration agreement, that is a way to argue that it's invalid. What's interesting is that the language of the statute specifically says that it applies to the case as opposed to the claim. And so I have some cases now, one in particular where we have a client who filed a claim under the FIHA for sexual harassment, but also has a Paga claim. And so under the federal statute, does that mean that her claim, her case, is precluded from being compelled to arbitration, right? Because she has a case that involves sexual harassment. It just happens to have a Paga claim in it also. You know, we'll see. It's an argument that we'll make. I don't know what the court will do with it. There's another legislative issue, or statutory issue, I should say. So the Code of Civil Procedure, California Code of Civil Procedure, section 1281.97 to 0.98 provides that where there is an arbitration agreement, if the employer fails to pay the fees to participate in that arbitration within 30 days, then the employee can argue that the employer has waived its right to arbitrate and essentially breached the agreement. That is a relatively recent change in the law also. And so I've had it come up maybe one or two times in cases, but defendants have been pretty good about paying fees when they need to, at least so far. The other option, kind of the nuclear option, I would say, is the prospect of mass arbitration. And so you may have heard of these types of situations where there's an arbitration agreement and there's no way around it. So instead of bringing a collective or class action, a plaintiff's firm typically will file successive arbitrations, individual arbitrations, usually about the same issue, to bring all of those claims against the employer, but subject to the employer's preference that they are going to be arbitrated as opposed to litigated. And so there's kind of an interesting example of this that I came across when I was getting prepared for this. There was a case against Uber where I think the issue was the misclassification of the Uber drivers as independent contractors. There was a fight about the arbitration agreement that ultimately resulted in approximately 31,000 individual arbitrations being filed against Uber. So another point of background, actually, for those who aren't familiar, in California, the employer is required to foot the bill for the arbitration, right? So when an employee files an arbitration, they have to pay what they would normally pay if they filed a court case, you know, $500 or whatever the filing fee is. But the employer is then responsible for shouldering the cost of the rest. And often in arbitration, if you go all the way, you know, could be, I don't know, $50,000, maybe more. Hannah probably has a good insight into that. But so considering that, Uber's faced with 31,000 individual arbitrations at however much a pop. That's a lot of money, right? And so Uber's put in this position where they get a bill from AAA for over $100 million just for the filing fees on that alone for the defendants. They tried to negotiate with AAA to come to what they felt was a more reasonable fee for arbitrating these cases. AAA didn't go for it and ultimately issued an invoice and said, look, Uber, if you're not going to pay this, then that's it. We're going to close these files. Uber filed a separate lawsuit against AAA, seeking a preliminary injunction, arguing breach of contract, a bunch of different stuff, but essentially trying to say that the fees AAA was charging for the arbitration were not commensurate with the work that it was going to do, and that they shouldn't have to pay it. The preliminary injunction was denied. It went up to the Court of Appeal. Interestingly, this was actually litigated in New York state court, but the New York Court of Appeal said that, this is worth reading the quote, while Uber is trying to avoid paying the arbitration fees associated with 31,000 nearly identical cases, it made the business decision to preclude class, collective, or representative claims in its arbitration agreement with consumers, and AAA's fees are directly attributable to that decision. That's an interesting or cautionary tale from my perspective. Obviously, it changes the way that, you know, the plaintiff's bar may have to litigate these cases, but this is certainly a viable option when you have an employer that has enough employees to make it worth your while. So I guess that's kind of my checklist of what I go through when I'm deciding, you know, whether to fight an arbitration agreement on one of these cases.
That's great. I think that's very helpful for plaintiffs' attorneys. You know, just to kind of recap it a little bit, you want to look at the arbitration agreement. You want to look at the actual language. Is there a waiver? Is there a severability provision? There's a great argument under the labor code that was codified 432.6. Is the arbitration agreement a condition of employment? If so, that's problematic. We have this arguments regarding the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act of 2021, does the case include a Paga claim? Or excuse me, does the Paga case also include a sexual harassment claim? Do you look at the case as a whole? Do you separate the claims? Max is kind of exploring that issue right now. And then you have the CCP 1281.97 to 0.98, which is breaching the arbitration agreement if payment isn't made within 30 days. And then, of course, we have the Uber example, which is a little bit of a be careful what you wish for example. I think that case is an interesting find. Okay, perfect. Well,
One
Sure.
thing that I want to make sure that I mentioned that I don't know that I did on the Chamber of Commerce versus Bonta decision. One interesting thing about that is that the Ninth Circuit also held that the labor code that precludes those mandatory arbitration clauses, it can't be used as a contract defense. So in other words, if you have an employer that violated that statute and required their employee to sign an arbitration agreement after the fact, if I was fighting that, I couldn't use that as a basis to invalidate the arbitration agreement. So make of that what you will, but.
Interesting. And the penalties, they said that those were preempted as well.
Yeah.
Okay, well, turning to Hannah, what are some of the practical implications from defense perspective for moving the case into arbitration?
Yeah, so I think from the defense perspective too, though, some of the things we do on our side as well before even, doing so is one is really looking at the arbitration agreement very closely as well. We do that on our side to make sure, and also, again, signature, authentication of that signature and all of those things. And then looking specifically at what that language is in the arbitration agreement, what was the process? Because being prepared to address all of the arguments just raised, we want to do that beforehand and anticipate them. And then normally what we'll do is we will ask to go ahead and stipulate to arbitration. And, again, we'll go through this process. And if we're forced to compel, then we'll move forward with compelling. But I think, with this, why did we want to push so much from the employer side for arbitration? And why is there this big push, right? Well, and I think it's because, a lot of what we're talking about is to avoid these claims being together, getting rid of that ability for people to bring, multiple claims together as a group. And that's been the problem dealing with Paga, is that we haven't been able to really do that and get rid of that. And so I think this decision, though, doesn't really necessarily solve that problem. And that's, I think when it first came out, it seemed like it was going to be great. And I'm not saying it's horrible, but I'm not so sure it's so amazing either. And then I think what in looking at what do we have to think about when we do actually compel arbitration or push for arbitration, when we're talking about a class claim, or we're talking about a collective action, or when we're now talking about Paga, are we going to end up with this mass arbitration issue? And I think that is a real concern and something to really think about. And all those points that were just made about, what has been this wave of pushing to get claims out of arbitration, and what are even just some of the other things that have been put in place. And another one is just that same code section, that CCP 1281.98 was just amended again. Another amendment, which is really to consider, is that if your arbitration agreement doesn't have the right language, then all invoices are supposed to be due upon receipt, and the actual arbitration provider must make them that way. So again, this is where, looking at the arbitration agreement language is important. And just another way in which potentially all the fees, like mentioned, $50,000, $70,000, $100,000 could be due very soon up front, and you're faced with a lot of arbitrations that could be really costly. So again, that's another reason why, working together and solving and, resolving things earlier might still just make a lot of sense.
Makes sense. And that's SB 762 for our listeners, the one that amended the 1281.98. Thank you, Hannah. So let's segue into our next issue, which is the Superior Court's jurisdiction pending arbitration. So what do you do with the representative Paga claim? That's what we want to know. So we'll start with Max. And so we have a situation where arbitration is compelled. The motion is granted. And basically, from the plaintiff's perspective, I want to know, does the Superior Court retain jurisdiction over the representative claim while the individual Paga claim is arbitrated?
Got it. So I'm dealing with a lot of these motions right now, and I don't have any that have been ruled on yet, but what I see employers asking for is for the court to compel the individual Paga claim to arbitration, which, remember, before Viking River didn't exist, and to dismiss the representative Paga claim because of some language in the Viking River decision. So in Viking River, after concluding that the individual Paga claim could be sent to arbitration, the court took it upon itself to decide what I would argue is an issue of state law with respect to the standing required to bring a Paga claim. And the Supreme Court said that once that individual Paga claim is sent to arbitration, that plaintiff wouldn't meet the statutory standing requirement under the Paga to be an aggrieved employee, and thus could not maintain the representative Paga claim, even if that part of the Iskanian rule still exists to preclude the waiver of that, right? So the first argument that I have made and plan to make is that the Supreme Court's decision on state law is not controlling, and there's support for that in Justice Sotomayor's concurrence. She said, of course, if this court's understanding of state law is wrong, California courts in an appropriate case will have the last word. So we'll be fighting to have that last word and to apply a different interpretation of the Paga. And there's California cases that support that interpretation. The most relevant is a case called Kim versus Raines. And in that case, the California Supreme Court held that an employee who had settled their individual labor code claims still had standing to pursue a Paga claim. Now, remember, at this point in time, there was no such thing as an individual Paga claim. All you had was your individual labor code claims that resulted in statutory penalties or damages, and a Paga claim that resulted in only civil penalties, not wages, not damages. So if you can settle out your labor code claims, but still pursue a Paga claim under Kim versus Raines, I argue that you should be able to succeed on your individual Paga claim in the arbitration and then pursue a representative Paga claim in court. There's another Court of Appeal case called Huff versus Securitas that supports that position. And in that case, the Court of Appeal said essentially that even if an employee did not suffer the exact labor code violation that's being alleged in the Paga case on behalf of other folks, they can still pursue it because, again, they're standing in the shoes of the government to enforce the labor code. I think we're going to see a lot of confusion in the trial courts about what to do in these circumstances, because it really is uncharted territory, and I don't think anybody knows exactly what's going to happen. But those are some of the issues I anticipate.
So from the plaintiff perspective, the individual Paga case is sent to arbitration. Meanwhile, the representative case in court needs to be stayed, figure out what happens in arbitration. If there's success, then come back to state court and proceed with the representative claim. Is that the
Yeah.
plaintiff perspective?
That's the hope. Yeah. Yes.
Understood. So then let's hear from Hannah. What is the defense perspective? What happens to the representative claim while the individual claim is arbitrated?
Yeah, and so from the defense perspective, I think, and we're seeing, and we are arguing in our motions as well, we have lots, and we are starting to see some rulings, and I'll talk a little bit about that. But what are we seeing and what are we arguing? So defense side, we're arguing as a result of the decision itself, and the language itself says, as a result of their holding, Moriana would lack standing to maintain her non-individual claims in court once they're compelled into arbitration, and the correct course was to dismiss her remaining claims. And that's what the court says. So that's what we're arguing. So the court should dismiss them for defense perspective while plaintiff arbitrates the individual Paga claim, which again is new concept, individual Paga claim. So every time I say it, I have to say that. But I think the next thought is, right, like what happens, and I think Max has just touched on that, right, is otherwise, then what's the alternative position is that it stayed if the court goes with his argument. And then what's the really bad worst case scenario? And I think that would be what Max would argue potentially. And I think we're seeing that being argued is that no, under Kim v. Raines, it should be continued to be pursued. And I think our defense response to that is no, there's no standing left to pursue an action in state court. It should be dismissed. And if the court doesn't know what to do, then okay, stay it, but not let it proceed. But we are seeing that too as an argument. But I think Kim v. Raines was distinguishable because as we're talking about, there wasn't this concept before about an individual Paga claim. So that wasn't even contemplated in Kim v. Raines. So for a court to go with it there, I think it is also a stretch. But we'll see, because I think exactly, I don't know. I think this is really all new territory, and we'll see how things play out and how courts rule, because they're going to have to make rulings on these cases. And, you know, without further guidance or anything, that's what we're going to see. And I think from the defense perspective, SCOTUS, you know, and the Supreme Court is really binding on California court, and there is line of cases, you know, that does support that. So it's our position that actually only the California legislature can make a change to standing here.
Understood. So defense perspective, to sum it up, is that the individual case, Paga case, gets sent to arbitration, and the representative case in court needs to be dismissed. Worst case scenario, though, it's not dismissed and it gets stayed. I think at least the plaintiff and defense bar can agrees that if it gets stayed, then the representative claim doesn't get pursued until you figure out what happens with the individual Paga claim. Is that a correct statement? Can we say that there's some agreement there between plaintiff and defense?
I don't know.
Max is like, I'm not going to agree to that.
All right. No, don't worry. No one needs to agree to anything on here. Okay, so let's get into our next topic, which is settlement. And I do see that we have a question from a listener regarding settlement. So let's get into our discussion and then we can take that question. The labor code says, and this hasn't changed, of course, that you need court approval for a Paga settlement. So the question is, after Viking River, what is your understanding as to whether the parties need court approval for settlement of the individual Paga claim? And Max, I'll let you start.
Sure. The language of the statute, I would say, does require it. It says that a superior court must approve the settlement. In practice, you know, I don't know exactly how this stuff will play out. I think that if it's an individual Paga settlement, there may be less interest in trying to present that to a court, but I think, technically the language of the statute would require it. The other question is, could an arbitrator approve an individual Paga settlement? I think that there is case law in other contexts where if a statute references the court and the claim has been compelled to arbitration, then the arbitrator would have those same duties or abilities. But I don't know, because is that something that would need to be articulated in the arbitration agreement? In other words, is that, are we going to see an arbitration agreement moving forward that says the arbitrator has the power to approve a Paga settlement? And if so, would that even stand given the language of the statute? I don't know. This is an area where I really have more questions than answers. The other thing is, if there is a settlement that's achieved and approved by an arbitrator, then that would ostensibly remain confidential, right? And that's one of the things that employers, at least I understand, employers like about arbitration is that it's confidential. But if you settle a Paga claim in arbitration and then have to go get approval in a public filing in the court, how is that helpful? So, I don't know, more questions than answers.
Okay. And Hannah, so from the defense perspective, what was the practice before when the parties would settle an individual Paga claim, and how will that change moving forward?
Right. So prior to this decision, when we would just settle out with an individual and let's say, we'll say scrap the Paga, we're just not going to settle that. We'll just settle with the individual. We just settle it and they dismiss it, and they would just dismiss the Paga claim. And at most courts, I really didn't have issues. I had heard of people having a few issues sometimes, but I had never personally experienced any issues in doing that. We just go ahead, file a request for dismissal. But I think now there's this concept, and I think there are a lot more questions and answers here in this area. I think we don't know what exactly the arbitrator would do. And then what about those payouts of penalties? It's that 75% goes to the state and 25% goes to the individual. I guess that's what we would be doing here, and so I think this is really an area where we're going to have to see what happens and see how these are handled, since it's a new concept to all of us. And then this, kind of what do we think will happen, next, really? So with that, I think what we can see here is that, there's going to be things that the courts are going to have to do, arbitrators are going to have to do, that it's new territory. And then we may see, further action, either at the legislative level. And then, as we mentioned on Tuesday this week, Moriana did file a petition for rehearing. So we'll have to see how that plays out as well. And, I don't think we're necessarily going to see much this year, because the legislature will adjourn August 31st. And so far, we don't have anything yet. And so we're not sure what will come next. It might be not until next year, but as we're talking about, who knows if actually there'll have to be action taken depending on how things play out.
Max, anything you'd like to add regarding legislative or judicial changes?
I don't think I have anything. I hope that the legislature responds. There has been indications that they will. I haven't seen any language, and we'll see what they come up with.
Okay, before we get to our final thoughts, I think this is appropriate time to answer this question. It says, what are your thoughts on the impact of Viking River on pending Paga settlement where a court has not ruled on a motion for approval? Any impact where proposed interveners are trying to intervene to stop a signed Paga settlement?
Sure. So I'm happy to take a first crack at that. I would say that there's absolutely no impact from Viking River. if you have a signed settlement agreement, because then it's just a matter of contract interpretation, right? You have two parties that agreed to do something. On the intervention issue, there's a case called Triada v. Lyft that says that you cannot intervene in a Paga action. That's currently up at the California Supreme Court. I don't think that it's been briefed or they've set hearing on it yet, but the Court of Appeal decision was that you cannot intervene in that circumstance.
Yeah, and actually I would agree with that. It's a contract issue there, and we've kind of discussed that. What do you do? And I think even on the defense side, we would agree there that if it's a signed agreement. And I think there was, and I'm not sure if it was that same case, but about a week ago came down saying you can't intervene. Another party can't intervene into another party's Paga case.
Okay, great. Okay, so let's start getting into our final thoughts. And I think the final thoughts, it would be nice for our audience to know what is your advice from the plaintiff and defense perspective moving forward? For the plaintiffs, do you think, Max, that plaintiffs are disincentivized from pursuing Paga cases now? And then on the defense, Hannah, and I think you might have touched on this a little bit, but is Viking River considered a home run for employers? So let's go ahead and start with Max first.
Thanks. I think it's too early to really say whether folks will be disincentivized. It certainly has changed the landscape of how these cases are going to be litigated. And I think that people may pay a little bit more attention to arbitration agreements, during their intake before they decide to file a case. Because, before, even if there was a class waiver, you knew that there would be a Paga case. So we'll see what happens. Mass arbitration is the other option where this could go. So we'll see as time goes on.
Okay.
Yeah, and I think, I've already kind of hinted at it and I didn't come out with it, right? Is that I don't know. I think defense was hopeful that this was a big win. And I think originally when this came out, I think if we had this webinar even a week ago, I think I might have been singing a little different tune. But I think we will have to see how things play out, because I think the case left a lot open to be argued and that we're going to have to deal with on both sides.
Well, I think that makes sense. Okay, well, that is the end. So I believe we have answered all of the questions, and I did answer, someone asked can Max provide the citations to the case he's discussing? I put my email address in the chat. You guys can go ahead if anyone's interested in or needs some case citations, shoot me an email and I'm happy to provide those to you. Because I know Max is an encyclopedia of cases. We've learned this throughout our friendship, but I don't think he has the citations memorized.
I do not, but feel free, anyone, to reach out to me also. Look me up on the Cal Bar website. You'll find my contact.
Perfect. All right. Well, if I don't see any other questions, so we can go ahead and conclude. Thank you so much to Max and Hannah. This was extremely informative. Thank you to the Beverly Hills Bar Association. And of course, a big thank you to our viewers for tuning in tonight. I hope you guys had some useful takeaways from this program, and I wish you the best of luck with your Paga cases, and good night.
Thank you.
Thank you.